Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines where my law partner Sean Fagan and I are discussing proposed legislation, new laws, in the Senate and the House of Louisiana that will limit the rights of victims injured in automobile collisions. It's also going to make it more difficult to pursue the claims in court. So please join us on the next Legal Lines with Sean Fagan and contact your legislature after you hear these things. It's not fair and it's not right. Hi, I'm lawyer Locke Meredith. We see this a lot. You're battling an insurance company because of a wreck, not your fault. They're not calling you back or being fair. You're injured, your car's damaged, and you need to see a doctor. You're in pain. You can't work, pay your bills, or fix your vehicle. You need help. Whether you hire us at all, give us a call, 272-5555, or email us at Locke Meredith, Sean Fagan and Associates. Better yet, come see us. We'd be honored to help, and you have nothing to lose. Hello, welcome to Legal Lines. I'm Locke Meredith. I'm pleased to have on my show my law partner Sean Fagan, and we're going to talk about some laws that our legislation is trying, or legislation laws that are trying to be passed by the legislature currently in extraordinary session. So Sean, let's kind of dive in there. It's purported to be tort reform, and the goal is said to be a hope, not a promise, not a mandate, not a you got to do it, but a hope that it would result in a 10% reduction in auto insurance premiums for folks. What's your analysis?
All right, it's being titled as the Omnibus Premium Reduction Act of 2020. It's exactly what you're talking about. There's no guarantee of a rate reduction, but what the legislature is doing is trying to pass laws that will take away a tremendous number of rights that Louisiana citizens have right now in exchange for a hope that maybe the insurance companies will reduce rates.
Well, and let's talk about that, the exchange. The big picture here is who's going to pay the costs related to a very serious injury that some one person or a family suffers. Let's say somebody's leg is chopped off, or they suffer back injury and they're paralyzed. Are we going to make it hard for that victim to get compensation from an insurance company or the at-fault party, which usually is the insurance company's not employee, but they're insured. Or are you going to make the victim bear the cost? You're going to make it more difficult for him to get recovery. That's the big balance here. Are we going to make the victim pay? Or are we going to make an insurance company that the whole concept of insurance is to spread the risk amongst all society by everybody paying a little bit for these catastrophic type injuries?
That's right, and what's happening now is the burden is shifting more and more to the person who was the innocent victim in the sense, right? The person who didn't do anything wrong but got hurt however they got hurt. And it's not really benefiting even the person who caused the harm. The irony is it's going
to the insurance companies.
To the auto insurance companies, and not all insurance companies, just the auto insurance companies that are benefiting from this. And so, for me...
Who can petition every time they want to have an increase in their premiums based on the actual experience that they have in the recent past. They go to the Commissioner of Insurance, they prove their case, and either he agrees or he doesn't agree. Well,
that's the thing that's aggravating about this, right? And aggravating is a very tame word to use the way I feel about this. Not a single insurer came in before the legislature to testify that they were going to reduce rates.
And Governor Edwards flat out said that in his veto memo.
And so what's happening is you go, how is it that 5, 6, or 7 different legislators, some in the Senate, some in the House, have almost identical provisions in the bills that they're submitting?
We know how, don't we?
With just some very, very small changes. But if you really want to know how that happens, and what's crazy about this is the public who's affected by this have no idea this is going on. It's not reported on. Nobody knows what's going on in the legislature right now. But the changes that they're talking about are so extreme, such a sea change in how it will affect people, and they'll only find it out when they get hit with it.
Well, and let's give perspective here. They tried to pass this in the first session this year in 2020, and there was an error in language, and the governor vetoed that all except one bill, which had related to attorney advertising. But he vetoed all other aspects. And his point was what we're discussing. Look, we've tried this one other time where we made a modification. It was no pay, no play. In other words, if you don't have liability insurance, then you're going to be penalized to the extent of the minimum policy that you would have been able to get, which currently is $15,000. Mm-hmm. So if you had a $20,000 injury, but you didn't have insurance, then you're going to get $5,000.
Yeah, we were using...
And it didn't reduce premiums.
Exactly. We were sold a pig and a poke, right? Because you and I both, when that was going down, you and I are both, fiscally conservative when it comes to these things. We recognize that there are things that need to be done in terms of tort law. And no pay, no play was the idea. Well, look, if you have no insurance at all, and you hurt somebody else and you've got no insurance, that person suffers the harm because they don't get compensated. But if you go out and you've got no insurance and they hit you, why should you get a recovery when you were putting them at risk of getting zero? So what the governor had proposed and the legislature passed was you're not going to get the first $15,000 that you should have bought to protect the people
What's
you could
good
have
for
hit.
the goose is good for the gander.
And so,
bottom line.
And the selling point for that was it's going to reduce premiums for everybody in the state because anybody who's running around uninsured, they're not going to get $15,000 in the first amount of coverage.
And the governor pointed that out also in this veto memo. He said, look, we tried this before. Within a year, the premiums were above where they were before it was implemented.
It's a pig and a poke.
So it doesn't work. And we've experienced this whole attempt to cap expenses by limiting damages available in the medical malpractice world. Yeah. And that's a joke.
Well, look, again, that's some of the things you're talking about is putting limitations like that on. That's a great example you're bringing up, the Medical Malpractice Act. Passed in 1976, 44 years ago.
No increase in the cap.
$500,000 cap, and for 44 years it stayed the same. So
think about that. That means you're saying a dollar bill 44 years ago would be the equivalent of a dollar bill today? And I bet it's not worth 1/10.
We did the analysis
10
on
cents.
It's remarkable how much less buying power there is for a dollar. But yet, so this is a case that we had, right? And this is one that illustrates the problem. 13-year-old girl suffers an amputation as a result of a mistake during a surgery. She has a prosthetic leg. Her future earnings are going to be affected for the duration of her life, and she's only 13. And there's a $500,000 cap on what she can recover that includes lost wages and any type of pain suffering that she has for the rest of her life as she goes through the changing out prosthetics and everything else.
It was a case you litigated in New Orleans.
That's right. And so you get this
multi-million-dollar judgment, but you couldn't get off.
That's right. So the jury awarded multi-million, and because that's how much the evidence showed her loss would be. The irony is this: I'm 55. Let's say I'm 64 and I'm getting ready to retire. I've had an entire life full of income that I've built and saved over the years to retire on. My recovery would be the same as that 13-year-old girl who's never even had a chance to get money in the first place from earning wages. That hadn't changed for 44 years. And so you go, how is it that someone at the end of their life, working life, is going to recover the same amount as someone who hadn't even started their working life?
It's absurd.
And that's why these problems...
It's inequality and it's unfair.
And it doesn't change.
And it doesn't fix anything and it hurts the victim. That's the bottom line. And that's what's driving our passion against this. All right, so now, he vetoed what happened in the first session. We're now in the second half, or they continued it the next day, this extraordinary session. And so now they're going at it piecemeal in some ways, combining some of it, but there's kind of like 9 attacks or 8 attacks in different ways. And we'll talk about each one of those, but again, the whole guiding concept is we hope we can get a reduction. It's never happened in the past, but we're gonna hurt victims. We'll continue it on the next segment. This is Locke Meredith Legal Alliance, partner Sean Fagan. We're talking about proposed legislation to hurt injury victims for no reason.
I'm lawyer Collins Locke Meredith. Trust is important when hiring an injury law firm. At Locke Meredith, Sean Fagan Associates, thousands have trusted us and gotten the results they deserved. Visit us at LockeMeredith.com. Whether you hire us at all, give us a call, 272-5555.
Hi, I'm Mitchell Meredith. Injuries happen when you least expect them to, making your life more complicated. At Locke Meredith, Sean Fagan and Associates, we know this and we strive to help each of our clients during these times. Whether you hire us at all, give us a call at 272-5555.
Welcome back to Legal Lines. I'm Locke Meredith, my law partner Sean Fagan. We're talking to you about some legislation being proposed right now in the Louisiana State House and Senate to basically, honestly, take away victims' rights who are severely injured for the hope that there will be a reduction in insurance premiums when the historical past tells you it's not going to happen. We've kind of talked about the big picture. Who's writing the bills, Sean?
Well, that's the thing, I guess we were talking about earlier, is you've got 5 or 6 different legislators that have virtually identical bills for the majority of the language, with some slight changes in them from bill to bill. And so you start going, how do all these folks have almost the identical language in there? And if you really want to know the answer to it, go around Baton Rouge, try to go to any steakhouse during when the legislature's in session, or any other nice restaurant. One, you won't be able to get a reservation. But I encourage folks, because nobody knows this is going on. I promise you the people in the audience.
Some big powwows.
Yeah,
huh?
they have no idea that any of this stuff is happening. But go out to one of the restaurants. If you can't get a reservation, walk through and see who's there and see who's paying for the bill. And those folks who are paying for the bill are the ones that are writing this legislation. And they're handing it to the legislators.
And they all work as lobbyists in some way, form, or fashion for the insurance industry, automobile insurance
They're
industry.
the only one, it is the only entity that's benefiting from this legislation, because it certainly isn't the citizens. And I'm not saying that as a plaintiff's lawyer. I'm saying that as a lawyer who looks at this and says, people need to educate themselves, and there's no source for them to go to because it's not being reported on because it's boring.
It's very important. Sorry, let's talk about the bullets they're shooting at folks, figuratively speaking. Let's kind of approach it from the procedural. All right, so you got to file a lawsuit. The first question is, are you going to file it in city court? Are you going to file it in the 19th JDC? And is it going to be a jury trial or a bench trial?
Yep.
How are they going at this?
What we've got, our system is set up to where city courts, the areas that have city courts, Baton Rouge has a city court, they deal with lower dollar amounts. And it's designed to where the folks who go in that have some sort of complaint or a monetary dispute, they can walk in there without a lawyer. And the judges are there to assist just people, as we would say, appearing pro se on their own behalf. They come in and the judges help them go through the process, and it's a very informal process.
Informal.
Yeah, right.
Not all the legalese and dot your I's and cross your T's.
Doesn't cost a lot of money. They're not a bunch of lawyers involved. Hate to say it because we are lawyers, but it's beneficial for those low value cases. Well, what they're doing is it's kind of a shell game. It's a complex deal, but they're lowering the jury threshold in district court.
Below that would allow you to go currently to the city court.
Well,
they want to force you to go to the 19th JDC.
Well, yeah, and it's even more,
or whatever your district court.
It's almost more aggravating than that. What they're doing is you have the right to go to city court, but then the defendant, the person who owes you the money, that you're alleging, can then say, okay, well, if I could get a jury trial in district court, which costs a lot more money to go to district court, I can force you to go to district court, which means you're then going to have to hire an attorney. And if you lower the threshold, because some of these bills are saying you get a jury trial at $5,000, well, the jurisdictional limit in city court goes up to like 10 or 15. So if you had a $10,000 or $15,000 case, you could have it resolved informally.
There might be 20.
Yeah, and so I lose track of it because we don't do as much in city court because we're not supposed to.
Yeah.
When you and I aren't in city court because that's designed to be handled by the citizenry.
Yes.
And so that means that someone goes in and they don't have the funds to hire an attorney for whatever reason. Now, since the jury threshold, if this law was passed, would drop to $5,000, the defendant can force you to go into district court. You can't afford to hire a lawyer. You walk away from whatever you're owed because you just can't afford it.
Or they threaten you to do it.
Yeah.
That's what they're going to do. So you take what they're offering you and they walk away.
And this
it's an abuse of the system as far as I'm concerned.
Well, and the thing is, it's a system they're creating, and it turns everything upside down. It takes away that one place you can go and get justice one way or the other, get a decision from a court without incurring a bunch of costs.
All right, prescription. They're proposing that it be extended instead of 1 year within which you have to file for the date of the accident, your lawsuit, to 2 years. Honestly, I have no gripe about that.
Louisiana has the shortest prescriptive period. A prescription period, obviously, is the time within which you have to file a lawsuit. From the date of injury, you have, in general, if it's a personal injury action, you have 1 year to do it. Louisiana's 1 year statute of limitations, as it's generally called, or prescription, is the shortest in the entire country right now.
And the rationale is that it gives the insurance company and the victim more time to get possibly fully treated and to try and resolve it without getting lawyers involved and all that.
Yeah,
that's fine.
So going to 2 years makes sense.
I think that's mutually beneficial for everybody, so no issue there.
Less litigation.
What are other bullets they shooting at our folks?
Looking down, I never make notes of these things, but there's so much going on here that I can't, put it all in my head. This jury trial threshold is such a big deal in district court. You got city court, you got district court, you got appellate court, and the Supreme Court. District court is where most lawsuits involving injuries and other disputes occur, right? This jury threshold, as I said, most of the legislation is the same, but there are slight variations in each one of them.
As low
right?
as 5, 10, 15, and 25 or something?
I think from 5 all the way up to 35, they want to reduce it from 50. Now, why is
Currently,
that a
it's
big deal?
50.
Right now, it's 50.
If you stipulate or your damages are less than $50,000, a judge will try the case.
That's right. And this legislation, hands down, will really only really benefit the auto insurance industry, not the other insurance industries. It's just auto insurance that's going to benefit from this.
That we're talking about.
So why is this a big deal? Well, at $50,000 and below, or below $50,000, a judge, you can get a bench trial. A judge presides over the case. What a judge has over a jury is experience. The judge can see patterns and can identify patterns of abuse, right?
They know the law, honestly. It's so interesting and I believe in the jury system, but to think you're going to read, a boring law, the text of it, and have it explained to you, and they're going to apply it correctly every single time, that's just not going to happen, sadly.
Yeah, and the vast majority of cases fall to $50,000 and below. So we'll go back in time, back when you and I were first practicing, and they had this. Some of the insurance companies, I won't name one in particular, used it the most. They had a computer called Colossus, and Colossus, what it did was they would punch in some information about an accident, and Colossus would spit out a number that should be paid.
Like the average of whatever they've been paying.
That's right.
And that was it.
And that was it. And so what would happen is, even the attorneys for the insurance companies were saying, hey, look, the facts of this case, the number you're talking about is absurd given the facts. They say, well, sorry, the computer says you should pay this amount, and that's the amount you're going to pay, otherwise bring it to trial. And if this was a jury trial system, a jury would never see that sort of pattern. Judges did, and they were able to address it directly, and Colossus generally went away, and it became case by case.
And actually, I think it cost that insurance company a lot more money in the long run in the judgments they ultimately litigated. Let's talk about the housing causation and the other bullets they're shooting at us on the next segment. We'll be right back. This is Locke Meredith, Sean Fagan. We're talking about proposed legislation that honestly limits the rights of injury victims. We'll be right back.
Hi, I'm Sean Fagan of Locke Meredith, Sean Fagan & Associates. Open the phone book or look online. There are plenty of lawyers to choose from. And if you ask any of them, they'll agree that the vast majority of claims settle without ever having gone to trial. And I'll tell you, any lawyer can settle a claim. It's not hard to settle a claim, but it takes hard work to get a client what he or she deserves. At Locke Meredith, Sean Fagan & Associates, we have a proven record of working hard for our clients. Whether you hire us at all, give us a call.
Welcome back to Legal Lines. I'm Locke Meredith with my law partner, Sean Fagan. We're talking about proposed legislation by the current legislature bodies, and they are pondering taking away, in our view, rights or making it more difficult for victims to pursue damages when they're severely injured. Sean, we talked about the threshold issue, and really what it does is it eliminates access to a jury trial that might exist.
To a bench trial.
Yeah, to a bench trial. And and explain kind of the practical. You were assistant DA and you had to get jury pools and pick juries. If they did this with a low number, everybody be getting a jury duty notice every other week.
Well, look, for probably most of us in the public have gotten those little notices that say you've been asked to come and potentially be picked as a juror, right? It is a great civic thing that makes us different from any other country.
I don't want to do it every other week, though.
That's right. So imagine if you're called away from work, because right now you don't get called away unless the cases are worth $50,000 or more, if it's an injury case. Imagine, as often as you get those notices, getting them 5 or 10 times more often, because for every $6,000 case, you're being asked to take time off of work
and give up your wages.
Get paid $8 a day.
That's right.
To sit around in a courtroom and make a judgment on a $6,000 case.
It's an excellent point.
And so you go, now wait a minute, aren't the judges trained and perfectly capable of doing this? And that's the system right now. Up to $50,000, you're getting the benefit of a judge who is out there doing this daily, so that everybody else can go and earn a wage and pay their mortgage, pay their house, pay their.
My recall is, and I've done a show with Miss Collins, who was the jury coordinator, and they were having a difficult time getting folks to show up at different times. So this would be a real procedural problem.
Oh, it's disruptive to workers. It slows down the process, because now you got to pick a jury. So what could be done by a judge in 2 hours now takes an entire day. So there's a huge backlog that builds up.
Yep. It's not going to expedite justice.
No, it's disruptive and it's expensive.
Yes.
It's expensive for everybody involved. So you go, why is this being done? And it's really just
trying to make it difficult to pursue your rights. That's the bottom line. Direct action. Explain to folks what it is.
Direct action allows a person who's injured to not only sue the person who is responsible for the accident, but also the insurance company who's going to provide the coverage. And so that's been the law in Louisiana forever. I want to say back to the 1910s, 1920s. And right now, it's really in the auto insurance company that's fighting this. They're saying, we don't want to be named in the lawsuit.
And the reason is, they don't want the jury to know that there's insurance coverage.
That's right. It's you go, what?
Even though the law mandates you have at least $15,000 in coverage.
Yeah, and let's even back up on that, right? What is it? The insurance company hires the lawyer for their insured. The insurance company calls all the shots strategically on how a case is to be tried.
And they're paid to do all
and they're
this.
paid. They're paid their premiums. Our premiums pay for them to do all this, right?
That's right.
Yet they're trying to pass legislation to hide it from the jury.
That's right.
That they exist, even though they're the ones making all the decisions before, during, and after the trial.
They have control when it's all said and done.
It's like Oz. It's like the Wizard of Oz. The insurance company is behind the curtain calling all the shots, but you're not supposed to know they're there. So I mean,
All right, let's move to that. I saw an attack on the Housley presumption of causation. If you get whacked by a pickup truck or an 18-wheeler, there's a presumption that it's, and you have injuries, there's a presumption that those injuries were caused because you got whacked by an 18-wheeler.
Yeah, again, something that's been around.
Common sense.
Yeah, it's common sense that you have a person that's been healthy before, and they have no medical history whatsoever. They get hit, or as you say, whacked by a big car, truck, whatever it may be, and then they have symptoms afterwards. The law recognizes that if you're in good shape before and you had symptoms that are related to the accident afterwards, that there's a causal relationship. For whatever reason, they're trying to say, well, no, we should do away with the presumption.
You can fight that presumption. The other side can fight the presumption, show evidence to the contrary, and then whoever's deciding, judge or jury, can say, yeah, we ain't buying the presumption.
That's right. It's not it's a rebuttable presumption.
To me, it's a common sense provision, but it doesn't sound like common sense is guiding these potential tort reform proposals. All right, so let's talk about the seatbelt issue.
Okay. Seatbelt, as it currently is, the law is that you can't put in evidence whether or not someone was wearing a seatbelt at the time of the accident. What the changes that are being proposed would say, not only does that evidence come in, but if there's evidence you weren't wearing a seatbelt at the time of the accident, there is an automatic 10% reduction in whatever you recover.
And even if there isn't an automatic reduction, they still can argue that, hey, you didn't wear it, it's your fault, you're 100% at fault, or you're partially at fault, and so whatever damage you get are going to be reduced based on what the judge or jury says is related to you not putting on your seatbelt.
And what's disturbing about the automatic 10% reduction, which is one of the
Which
is
is,
they're
to me,
proposing,
is the most, it's absurd.
Well, the reason why is this. In law, you have to prove everything what you're trying to say is it happened, right? And so the question would be whether or not the lack of wearing a seatbelt added to the injury, right? So let's say you get hit from behind. Well, if you get hit from behind, you're going backwards in your seat, the seatbelt's going to have no effect. So even though the jury may conclude that this not wearing the seatbelt did not add at all to the injury, this law would say you have to penalize the victim 10%, even though it had no causative effect for the injury whatsoever. It makes no sense. That's why we have juries.
It's really punishment,
Well,
what it is.
Well, because that's why you have juries.
Right.
Juries
They're the
look
ones
at,
that should decide it,
Yeah.
not some legislator writing it in a thing that has no knowledge of what the facts are at all.
So that's what was so
All right, let's
offensive to
talk
me.
about the last big attack, as I recall, and that's the collateral source. I've read it, simplify the collateral source rule. Kind of tell folks what's going on.
All right, so the collateral source rule basically says that if you're smart enough and resourceful enough to buy, let's say, health insurance, and you've been paying premiums for your entire life,
Or disability insurance.
Whatever
To pay for wages if you can't work.
That's right. So whatever you've been taking money out of your paycheck every week to pay for this, someone hits you, and now as a result of that, your health insurance steps in, or your disability carrier steps in and offsets you get what you paid for, right? They offset what your loss is. Well, the question is,
Well, let's give an example.
Yeah.
I get hurt. I'm disabled. I've got insurance, disability insurance. They pay me $10,000 for the wages, and instead of me getting to keep that and then also pursuing the guy that hit me, now they may have subrogation rights and they can get it back from me if I get it from an at-fault party, but if they don't have subrogation rights or they waive them, and I'm going to get the money from the at-fault party, the guy that hit me, that wouldn't be allowed now.
No, right now
they would get credit for me paying money to this guy over here, and it would benefit really not even the guy who drives his car incorrectly, negligently. It's his automobile insurance company.
That gets the benefit of the money
with
you
the
paid.
hope that they're going to save 10%, maybe.
Yep.
Unbelievable.
That's it. So I know we're running out of time. There's a whole other segment we could do on this.
Well, we will. So the bottom line is we just really request folks get educated on this stuff, contact your legislators, and tell them you want them to be fair and represent you and not the automobile insurance companies. We'll see you next time.